Thank you, Dr. Traver, and welcome to everyone. It's good to see everyone. This has become very much a bright spot of every semester, hearing the faculty and what they're doing and learning about the research. I'd like to thank Dr. Pelletier for presenting today and sharing with us the interesting work that she does. I'm looking forward to hearing about it. And I would also like to thank once again Dr. Traver and Dr. Zeltzer for all the time they put in. There's a lot of work that goes on behind the scenes, and it's very nice that they have been doing this. It's a very nice event for the department. So welcome to everyone, and thanks so much for being here.
Everyone, thank you. I'll echo Dr. Jankowski's comments. This has been such a nice treat for all of us as a department each semester to learn from our faculty about what they're up to. And I'm so glad that our students are joining us now too for these events and really experiencing what it's like to be involved in research from the faculty perspective. So no one came to hear me talk, so I will introduce Dr. Pelletier and her work. So Dr. Emily Pelletier is an assistant professor at QCC in our department, the Department of Social Sciences. Her academic background is in law, public policy, and criminal justice with a focus on juvenile justice policy. At QCC, she teaches courses in criminal justice and American government. And I'll just add something that she's being very humble. She actually has a law degree and a PhD, so she's quite exceptional. And we look forward to hearing from her. Thanks, Emily.
Thanks so much. I'm going to go ahead and share a PowerPoint that I have. So thank you everyone for joining, and a particular special thank you to Dr. Traver and Dr. Zelfer for organizing all of this. I am Emily Pelletier, and I'm going to be talking today about a project that I've been working on in which I've been taking a look at purpose clauses within juvenile justice codes across the country. So just to kind of give you an idea of what to expect from my presentation, I'm going to start out giving some background on juvenile justice laws, introduce you to some of the themes that are very commonly talked about within juvenile justice. And then I will present my research question that has been guiding me through this project. I'll talk a little bit about the project data, and I'll show you an example of data. I'll talk about the methodology, the findings, and the themes, and why I think that they are interesting and potentially important, in particular for thinking about future opportunities related to juvenile justice policy and practice in particular. So to just give you a little bit of background on how the juvenile justice system was created in the United States and what some of its origins are, it emerged in the late 1800s from this movement that was called the Child Savers Movement. And this movement had a rehabilitative ideology and rhetoric. So this group of people was really interested in providing support and services to youth in this time period. But it's really important to note a lot of the social changes that were going on at this time. So there was a lot of urbanization. There were a lot of people moving from more agricultural areas in the United States to more urban areas. There were changes in immigration at this point in time. There were people that were immigrating from countries that were more in Southern and Eastern Europe and who were less frequently English speaking. And then there was also industrialization. So people were working more in factories as opposed to being on farms. And from this, we saw an emerging concept of childhood also. So kids were no longer strictly viewed as miniature adults, but there is this emergence of thinking about them as in a particularly special time period of development in their own lives. And all of this really came together to both create the first juvenile court and also to create the concept of delinquency, so that youth who are engaging in socially inappropriate or offensive behavior would be able to be put into these special juvenile courts. So the first one emerged in Chicago in 1899. And the framework and the laws for this court in Chicago were essentially replicated across the country, oftentimes in urban areas, and then growing to other parts of the state. And these courts oftentimes heard all things that were related to youth. So they were hearing issues related to this new concept of delinquency. They were hearing issues related to child welfare. They're hearing issues related to unruly behavior, perhaps in school. So it was under this broad umbrella that the laws started to develop. And oftentimes the consequence for youth being put into one of these juvenile courts was that they were placed in out-of-home, what were called training schools, industrialized training schools. And this removed them from their families and removed them from their communities. So this is the initial framework of the juvenile justice system and a lot of the laws. And I think as later on, as I go through some of my own findings from the purpose clauses, you'll see these themes repeated. So that was the framework of the juvenile justice system in court up until approximately the 1960s. And during this time period, it was recognized that there was a punitive element to this juvenile court. It wasn't just providing youth with these holistic wraparound services, but there was particularly being removed from the home and removed from the community was punitive to them. And this really came to light in terms of the laws in juvenile justice with this particular case called Enrage. And in this case, Galt was 15 years old and he was accused of making a lewd phone call to a neighbor. So he was arrested and pulled into the juvenile justice system and had his hearing. He wasn't, nor were his parents initially notified of the charges. There weren't any witnesses. There was a lot of discrepancy in terms of whether or not he was actually the one who made a phone call or if he was with a friend who made the phone call. But regardless, the court essentially sentenced him to this industrial training school until he was 21 years old. So this would have been a 6-year time frame from him being 15 to 21. And he appealed this. He disagreed with the decision of the trial court and he appealed it, and it went all the way up to the US Supreme Court. And the Supreme Court essentially agreed with Galt and said that he had, as a child, and youth do have due process rights that need to be protected when they are in juvenile delinquency court, especially if there's the possibility that the youth is going to be removed from the home and put into any type of confinement facility. So the US Supreme Court affirmed a variety of due process protections, including the right to notification of charges, the right to cross-examine witnesses, the right to not incriminate yourself. And these were all protected by, in particular, the right to a defense attorney. And again, this is this approach to juvenile justice changed the conversation from being only about rehabilitation to also needing to protect the due process rights of youth. And a lot of times these can be considered in tension with one another and offer the framework of conversation around juvenile justice laws. There have been additional eras and other considerations that have come into relevance with juvenile justice policy since Enrage, and I'll just kind of go through quickly a few of them. So we had what's considered the Get Tough era of the late 1980s and 1990s. And at this point in time, there was a myth going around of a super predator youth who had a high propensity for violence, and this prediction that there was going to be an increase in violent juvenile crime. And this was entirely wrong. It didn't end up being true at all. However, the impact of this super predator myth created changes in policies in the juvenile justice system across the country. So in particular, we saw it was easier to transfer youth out of the juvenile court into the adult court, losing some of the protections and rehabilitative ideology and rhetoric of the juvenile court. And then also just an initial lowering of the age for adult court. So youth were just automatically charged in adult court and did not even begin in juvenile court. So there was a punitive element that came in and changed a lot of the policies during this time period, some of which have been rolled back since, but not all of them. And then in the early 2000s, we start to see more focus on adolescence, brain development, and adolescence as a particular time in life in which decision-making can become more impulsive and riskier. So some of the policies that we see in juvenile justice statutes across the country reflect this. So inclusion of brain development research for adolescents, positive youth development approaches. So this is the idea that youth can be and should be an asset within their community and the social connections that they have, that they're not necessarily viewed from a deficit lens, but that they can have positive roles and relationships and responsibility within their community. Also restorative justice approaches. So the idea that someone who is offended and someone who's been victimized and anyone in the community who's been impacted can come together and have a dialogue and try to resolve the problem in that way. And then we've also seen a move toward evidence-based approaches and assessments. So looking at data and looking at empirical evidence to determine what is working and whether or not we should continue using the particular practices and policies that we have in place. So this all shapes my interest in looking at the purpose clauses of juvenile justice statutes across the country. So in the states, there's usually one section of the statutes or codes that are geared toward youth who are in court. Sometimes they're separated by delinquency and dependency, and sometimes they're in the same, they're put together in the same context. And at the top of most of these, there's what's considered a purpose clause. And the purpose clause sets out the goals for all of the statutes and laws that follow. So I was interested in knowing what are the goals of state legislatures in passing statutes that comprise the functions of each state juvenile justice system, because we have all of these different historical context and influences that have come into play within the juvenile justice system over the decades. So I looked at all 50 states and Washington, D.C., and ultimately determined that 3 states did not have purpose clauses suitable to this project, but most of them did, and I pulled them all and took a look at them. So this is an example of Pennsylvania's purpose clause, and I use it as kind of an average example. So some purpose clauses are much longer, some are much shorter, but this is fairly average. And I know it's a lot of text on the slide, but I just wanted to give you an idea of what it looks like, and then also draw your attention to some of the highlighted phrases on there. So you can see right at the top that it indicates the purposes of the chapter. Most purpose clauses have a similar phrasing or use words that indicate that this is the reason why the statutes are being pulled together, the purpose or the goals. And then as you go through looking at the highlighted, you can see all these different phrases. So things like care, protection, safety, rehabilitation, accountability, responsible productive members of society, evidence-based practices, least restrictive intervention, a fair hearing, constitutional and other legal rights. So you can probably already hear some of the themes that were present in the history of the juvenile justice system coming through in these purpose clauses. And some of them may seem like they intuitively go together, and some of them seem like there could be some tension. But my project was interested in looking at what are the themes that emerge from all of these different phrases within the purpose clauses. So I did a content analysis for the latent meaning of these phrases. And what I did initially was just take a look at all of the purpose clauses and read through them and see if I could get an understanding of what the data look like on the whole, and then what are some of the patterns that immediately emerged for me. And then going through the data several more times, I was able to create essentially smaller subcategories that I was able to group into larger categories, and then ultimately come out with a few themes. And I created a code book that gave me a guide as I was going through, so I could remember what I was doing and which phrase went into which category and why. So that was really helpful for me. And as I coded, I also want to say that the categories weren't mutually exclusive. So in what you saw with the Pennsylvania statute, that's how many of them were. So the statutes fall into different types of categories within one state. And I use this to determine what some of the major themes are for the purpose codes across the United States. So these are the themes that emerged as I did this content analysis. And the first column I'm going to focus on a little bit more because these were the most prevalent themes that came out. And then the second column, I'm just going to kind of note them for a minute at the end because these were the less predominant ones that came through in the analysis. So the first primary theme was rehabilitation. And this is probably not surprising to anyone hearing about the origins of the juvenile justice system. So words that went into this particular theme were treatment, rehabilitative, guidance, therapeutic. These all fell under the rehabilitation category. The second category was limitations on system involvement, which is something that I wasn't expecting to come out as such a prevalent theme, but it did come out, and the phrases that went into this category were references to limit removal from the home, minimize the depth and duration of involvement, to deinstitutionalize. And while this reflects the concerns of Enrage foundations of that case, I thought it was interesting. I still didn't expect that this would come out to be one of the themes that emerged. The third one was social contract governing public life. So this was references related to public safety, public peace, protection of the public, and just generally references to the need to maintain the well-being of the community and kind of this implicit agreement that people are engaged in that they're going to contribute positively to the well-being of the community. Rights of parties. A lot of the language in the purpose codes were not directly offering due process protections for youth. It was more broad language about rights to every party who was involved. So this could be youth, it could be parents, could be victim. So farther down in the statutes, there could be a reference that's actually giving youth a particular due process right. But for the purpose clauses, it was a more broad right to party theme that emerged. And wording there was fair hearing, statutory rights, legal rights. And then the last one that was really predominant was accountability. And this was much more about the individualized accountability for actions as opposed to the social contract public welfare. And wording that came out was accountable, responsible to, personal responsibility. And then just to note some of the other ones that were that occurred on occasion, but were not as predominant, were references to punishment, control of youth, evidence-based practices, specific considerations for youth, either as competency or development, victim involvement, and then references to fiscal resources, things like auditing or grants. So I thought that this was really interesting in terms of both the content that was in the purpose clauses, and then also thinking about how this can help shape the role of the juvenile justice system moving forward. So if we're thinking about rehabilitation in particular as a predominant theme, we can also be thinking about, well, what is actually offered in terms of rehabilitation? What are the supports that are being given to youth? And youth are not operating on in their own little bubble. They're in conjunction with family and community and schools and other social institutions. So how are services or programs being offered that are rehabilitating youth? And also, how are we conceptualizing rehabilitation? Positive youth development, I think, offers a important framework of looking at youth as being, particularly adolescents, being in a time period in which it's normative to be making risky and impulsive decisions, and thinking about using the strengths of adolescence and looking at youth from a strengths-based paradigm to be able to support them. So a perhaps different conceptualization of rehabilitation. Limitations on system involvement. So in what ways are we limiting then youth contact with the system if we're thinking about the three major areas of criminal justice or juvenile justice, law enforcement, courts, and corrections alternatives? So thinking about our law enforcement officers within schools, in particular, if a youth is in the juvenile justice, has contact with the juvenile justice system and then returns to school, and their probation officers located within that school, they're still in contact in a daily basis with the system or if there's law enforcement within the school. Same thing with courts. How can we be limiting some of the contact with courts? Are there alternatives such as youth courts that are run predominantly by youth, or restorative justice practices that can be put into place, and corrections alternatives, so community-based organizations, community-based initiatives, so that youth are able to remain in their family, in their community, in their schools, connected with other social institutions. That does help limit the system involvement. And since these are our two most predominant themes, they really go hand in hand in thinking about the way in which the juvenile justice system can be providing something other than the punitive results that oftentimes it does create. For social contract and governing public life, I think there's an opportunity here to just reaffirm the role that youth have in their communities, and that they're an important part of the community and they're an important part of public life, and being able to give them the opportunity to enhance that role. If we're going to say that they are going to be responsible essentially for maintaining the general welfare and punished if they're not, then we can also be offering them the positive aspect of that too. Due process rights, so making sure that youth have due process rights that are protected, in particular by having access to defense attorneys. And then accountability came up, and oftentimes accountability was about the youth being accountable or the parents being accountable. Very infrequently was it the system itself accountable. So we can start thinking about the question, who is accountable to whom and for what? And then also, in what ways can we have the system be accountable to the youth, and not just the youth have to be accountable themselves? So that's really more specific to the themes that came out. And I just wanted to take a minute to also talk about some more broad future opportunities that I think emerge from this. And the first is evaluation. So if the purpose clauses are supposed to be identifying the goals of the juvenile justice system in that particular state, then whether or not those goals are being reached can be looked at from the purpose clause standpoint. So asking, are we doing the right things? Are we actually trying to provide rehabilitative supports or limiting system involvement if those are the goals in that state? And are we doing the right things? So are youth actually receiving these services, and what are the outcomes? What benefits are they receiving from these services or from limited contact? And if they're not, then they're not receiving benefits. What changes need to be made to the laws and the policies and the practices of the juvenile justice system? And this also kind of ties in with thinking about measures of success beyond recidivism. So the goal can be something other and is, as presented in the purpose clauses, something other than just re-entering the system for a second or third time, but thinking about what are some of the positive impacts, increasing school engagement, increasing pro-social relationships through mentorship with adults, and other types of measures to identify success that are directly correlated or corresponding to the purpose clauses. And then incorporating additional or alternative frameworks. Positive youth development, which I talked about a little bit, and restorative justice are just two of several different types of frameworks that could be considered as part of the juvenile justice policies when we start looking at what the goals are through the purpose clauses. So that is a quick overview of the work that I've been looking at and engaged with, project that I've been working on recently. So thank you for your attention, and I'm very happy to answer any questions that you might have.
Thank you, Emily. That was great. So interesting, and a wonderful example of the qualitative research that we do. I have a question that I'll kick things off with, and then we can open the floor. Can you tell us a little bit about the connection between this kind of research and change in the system?
Yeah, so I think it presents an opportunity for change in the system in terms of going through an evaluation. A lot of times we do think about evaluation more quantitatively. So it's looking at what we can measure and the number or the rate. And then once we're able to measure that in a concrete way, that gives argument for creating policy change. The other thing a lot of times are fiscal resources. So what is costing money, what is saving money? And those are the two things that I think usually end up driving change at the policy level. I think that this type of research, I hope that it opens up more of an approach that really looks at what are the perhaps unspoken goals, and look at it in terms of how can we adjust our policies based on these goals. And I only looked at the purpose clauses, which are just one component of many different statutes that go into governing the juvenile justice system. So I also think there's a lot of opportunity to just go through and say, well, if this is what our goals are, do all of the other laws that we have in place support those goals or not? A lot of times the purpose clauses get changed. There's something small added to it. And there's not necessarily a connection between what is going on in the other statutes. They don't always go back and reconnect it to the purpose clause. Sometimes legislatures do, and sometimes they don't. But I think this offers the opportunity to at least reflect: are we working on achieving these goals with our laws? And if not, how do we change it? And I think that's a very different conversation than what are the fiscal resources that we have available to us.
I'd like to follow up on that question because and also say I really loved hearing about this. As a big fan of qualitative research, and you had just mentioned identifying things that are like not explicitly stated or spoken, which is an approach that I like to take, and I think is really interesting and fruitful. But I wonder, especially given what I've just learned about your legal expertise, in terms of like making changes based on the results of this kind of work, do you think that there's the fact that you could identify something that's like implicit but not stated explicitly, would that be a barrier to, bringing about a change? And that, like, according to the legal system, and again, I am completely a stranger to, how that works in the particulars.
Yeah,
it's not explicit with that. Yeah, I think.
Yeah, I think you raise a good point. And I think that this is somewhat idealistic. I think a lot of times the changes are either going to come through case law. So there's like a particular case, and then it builds on the precedent, and you end up having a change that way, looking from like kind of a strictly legal framework. Sometimes you have an incident that occurs, and that it creates people wanting to make change. Like I said, finances can also be something that tends to drive change. I would hope that people would be interested in the qualitative work, but I do think it's a little bit more of an idealistic approach to it.
But very interesting, important. Thank you.
Thank you. Tabine, go ahead.
Okay, so I had the question. Can you guys hear me?
Yes.
Okay, so my question is like, what change, if any, are you like hoping to do through this research? Like, what changes in juvenile justice do you want to occur in the future?
Oh, that's such a good question. Thank you. I mean, personally, for myself, I know it might be a little bit ideal, but I would really like to see a little bit of an opening in juvenile justice policy to provide some of these alternative frameworks. So looking at positive youth development, looking at restorative justice practices, looking at youth courts and how they're working, and be able to incorporate them into some of the policies. So a lot of times the conversation is very much about rehabilitation or due process rights or punitive sanctions, because that's where the history of the juvenile justice system has its roots. And I just would like to at least begin by trying to open up the conversation and saying, well, if we want to be thinking about rehabilitation, how can we think about it perhaps more broadly? Or if we want to be limiting system involvement, what are we doing to try and actually make that possible for youth? And I think those conversations, I don't want to say I'm totally idealistic, because I think that those conversations are happening. And I would hope that this encourages people to have more of them.
Dr. Pelletier, can you tell us a little bit more about two of the options that you just mentioned? Many of us are probably familiar with restorative justice, but the positive youth development and the youth courts, what do those actually look like on the ground?
Yeah, so positive youth development is a framework that's oftentimes put into what is called out of school time programming for kids. So after school programs and other types of more recreational. And this framework is really looking at kids from a positive assets-based, strengths-based perspective. So talking about how they are resilient, how they're able to achieve competency and have responsibility, particularly when they're connected to something that they're really interested in, something that sparks with them, and giving them the opportunity to learn and to serve and to benefit the community. So again, a lot of times we see this in after-school programs or prevention programs, and it's starting to move a little bit more into the juvenile justice system in the past 10 years or so. So that particularly alternative to incarceration or confinement programs are connecting youth with these types of opportunities and trying to see youth really as normative and resilient and able to make positive contributions to their community. And then in terms of youth courts, they are usually related to what would be considered more low-level offenses. So, someone has done something that is offensive to someone else, and the court a lot of times is run by youth. So they're going to be the ones who are potentially acting as the attorney. So they're acting as the advocate. They can be acting as a jury. They can be acting as a judge. And then there's usually an adult component who's overseeing it, but it is an alternative way to kind of work out some of the conflicts that they might have. Again, it's more for lower level of offenses, and it's distinct from restorative justice.
Emily, question for you, but you hear me?
Yes, I can.
I think some question kind related to that. I'm talking about restorative justice. Mostly, why United States is really not focusing on that, and it's due because of the.
I think I'm missing parts of your question. I'm not sure if.
So my question is, everybody talked about restorative justice, but usually in America, we're not focusing on that. That's due because of the get tough policy, because we know restorative justice function well in Canadian system, and also, I'm not saying they're better, but they have a focus on that. It's a way to send the kids in mass in jail than the United States. Restorative justice is because of the get tough policy in the 1980s.
Okay, so I think I caught that. I'll start answering and let me know if you want me to go in a different direction. I think one of the interesting things about restorative justice and youth is that these restorative justice practices are being implemented in schools at this point in time across the US in different schools. So it's a way that the youth are familiar, and in some ways they're trained to do and engage in restorative justice practices within the classroom. So moving it into potentially the court system is maybe a next step that would be able to be taken. And the idea that they're coming together and identifying the harm that's been caused and being able to work through it together outside of the involvement with teachers or with principals or with law enforcement officers, school resource officers that might be in the school offers an alternative. And then we're also seeing restorative justice practices being used in some of the smaller group homes that are being put into place as opposed to the large confinement facilities. So within the juvenile justice system, we're also starting to see conflicts that perhaps arise among the 12 or 14 youth that are in that home. They're using restorative justice practices to work through those as a house. So they are being put into place, and as far as I know, having positive impacts where they are being used. So, thinking about the way that they can be moved into some of these other areas of the juvenile justice system, I think is an interesting thing to consider, at least.
A question for you, very interesting work. For students who are interested in studying either any of these issues or reforming the juvenile justice system, what area would you advise them to go into? Would it be criminal justice, sociology, the law, or would it depend on certainly what they're really interested in focusing on?
I think so. I think I have many different answers. I think that it should stem from what they're interested in focusing on. So if there's really an effort to try and think about public policy and reforming public policy, thinking about political science, possibly criminal justice, social work, if there's an interest in more developing some of the programs or developing some of the different practices that can be used in the juvenile justice system, then I would recommend more of a social work approach or psychology, perhaps. If the interest is really advocating from a legal framework, then and an interest in going to law school, then essentially any major that you're interested in that has a lot of reading and writing is really important. Because those are skills that you're using frequently in law school in the practice of law. So I do think it depends on what your interest is and to follow that. And there are many different overlapping sectors and overlapping skill sets that come into studying this field.
So we have a question from Professor Zeltzer in the chat. He seems to be pointing towards the sort of form of the purpose clauses. Is there a lesson for purpose clauses? Can we write them in a way that produces better results?
Yes, I think so. I think just first reviewing them and taking a look at what's actually in them. I might be a little skeptical, but I don't know how many times they're actually read, because a lot of times what is being looked at from a practice standpoint is the actual content of the statutes below. So what process or practices need to be put into place at what time period in which the youth is in contact with the system. So I think that the purpose clauses probably do tend to just kind of fall to the wayside because they're not, they don't have a lot of legal power to them. They're just generally an overview. So I think that just looking at them and reviewing them and seeing where they're in contradiction with one another, and definitely streamlining perhaps in relation to what follows within the statutes, so that they provided a easier to follow guide and, in my opinion, easier to follow framework for evaluation.
Thank you. And Brooke also had a question. Brooke Gonzalez had a question about the model that these efforts might provide for adult carceral systems. So do you think our justice system could benefit from trying to rehabilitate adults that are incarcerated for charges like drug use and possession, rather than incarcerating them in the way that youths are attempting to be rehabilitated? It's a great question.
Yeah, I really like that question. Yes, I think so. I think that these are overlapping issues, and I definitely think that what is considered within the juvenile justice system can be considered in the adult system. Also, a lot of times we do have this more rehabilitative social work type of approach within the juvenile justice system, and it is championed, at least in terms of ideology and rhetoric within the juvenile justice system. But I think that it can absolutely apply to the adult criminal justice system, especially if we're looking at a framework for the system that is more focused on rehabilitation as opposed to punishment.
I have a question. So, you know how you did the analysis to figure out what the general theme for each state. Do the states themselves have evaluation about whether or not their policies is working to serve the purpose clause at all?
That's a good question. I don't know specifically. I find just my kind of limited knowledge of evaluation in different states, I find that they tend to be more like any evaluation that's going on is really specific to a particular practice that's being conducted within the juvenile justice system. So perhaps, as I mentioned, moving youth out of large confinement facilities and moving them more into smaller group homes, that might be something that's specifically evaluated, or the use of an assessment tool for determining risk or needs. That's something that specifically might be evaluated. I actually don't know, and you raise a great question. I'll have to look into it. If purpose clauses are being used as an evaluation component or a framework for evaluation, I tend to think not, that they're just kind of there as a ideal statement, and they're not looked at specifically. But that's a good question. I'll have to look into.
Right. So these ideal statements aren't their policies driven by these statements? Because you mentioned that before, right? The policies and the laws and practices, right, are driven by these statements. And so they may create these policies to serve this overarching goal, but so no one knows if it actually does what it's supposed to do.
Yeah, and sometimes, the purpose clause is adjusted. It says that it wants to, for example, with Enrage, the purpose clause might be adjusted to say that we want to give rights to the parties, and then farther down in the statutes, the statutes will offer the right to an attorney and protect that right for the youth.
Right.
But sometimes there's just a change that might be made farther down, and it's not reflected in the purpose clause at all. So they're not always done together, which creates distance sometimes.
Right. Cool.
But ideally, the way it's set up and the way it's supposed to be is that schools are there.
Right. Up, down.
Yeah,
Yeah.
exactly.
Yeah.
So the floor is open for other questions, but I wanted to follow up on something that the last question made me think of, which is, did you see any interesting outliers, or was there anything revealed to you by the clauses that didn't follow the themes? And were there certain consistencies about the politics of the state, or even themes within the outliers, if you will?
So in terms of outliers, I think I was kind of, there's only a couple that were referencing like fiscal resources or auditing. And I thought that there would be more components of that within the purpose clauses, because like I said, a lot of times the fiscal resources end up driving policy change. And that's an interesting question in terms of thinking about the political or other social contexts for the different states in comparison to the purpose clauses. It wasn't something I was paying attention to as I went through it, but I bet that there are different connections there that could be identified. And then I also, I know that like going through, there would be this tension between rehabilitation in particular and punitiveness, or a need to hold a youth personally responsible. Those didn't seem to necessarily be written in a way in which they were supportive of one another. It was kind of, one would say, well, we want to, offer treatment, and then the other would say, well, we need to really sometimes use the phrase of punishment, or have a hold personally accountable for different actions that the youth is engaged in. So, I think that that's something that can be looked into further in terms of are even the purpose clauses within a particular state supportive of one another.
We have another question in the chat from Professor Bordoni. Which state is the best example for these types of programs? New York has OST, but not sure about modern juvenile justice policies like youth courts.
Yeah, that's a good question. I don't know that I can call out a particular state for being the best in terms of their policies. I think that different states have different strengths. I do know that New York has been on the forefront of moving, particularly in New York City, moving youth out of confinement facilities that are located upstate and moving them into what are considered the close to home facilities within New York City as an attempt to try and keep them connected to families and communities and resources that are available to them, mentorships, and other things that can contribute to positive youth development. And that they've been, in addition to Missouri, that they've been on the forefront of really putting that into practice. So I know that that's one of the positives from New York State.
Perhaps, Dr. Pelletier, you can tell us what's next for you. What other projects are you working on? What might students think about talking to you about in terms of your research?
So I'm trying to stay within the policy realm of juvenile justice. So I'm hoping to take these and identify some accountability components to it. So one of the questions that came out for me was this idea of accountability. A lot of times these purpose clauses talk about youth being held accountable or parents being held accountable. And I'm interested in going through and looking at in what ways is the system going to be accountable to the youth? So either there's that phrase in there, which I found very rarely, or thinking about the use of evidence-based practices for assessment, things like that. How is accountability? I'd like to tease that out a little bit more. And then also perhaps looking at the other statutes that are in these codes and whether or not they are in alignment with what's in the purpose clauses. So if you're interested in reading policies, let me know.
We have another question from Brooke. Thank you, Brooke, in the chat. Do you think there's a particular theme that is most important or can be the most detrimental if not followed? That's a very thought-provoking question.
Yeah. I actually think maybe rehabilitation is the answer to both of those. I think that how we consider rehabilitation is really important, and thinking about what are the goals of rehabilitation? How are we honoring youth as this asset? Is that coming through in what we consider rehabilitation? How are we supporting youth where they are and identifying their unique needs? So I think that rehabilitation can be something that's really positive, or it can be detrimental if it's not used in a way that is supportive and celebratory of youth and the strengths that they have, both as individuals and within their families and their communities. So I think that we have to be careful. A lot of times the ideology and rhetoric of rehabilitation is that it's wonderful, but I think that we can be critical about that, and it can go either direction.
Professor Pelletier, maybe as a way of taking us out and tying up our time today, do you have any reactions to the new anti-violence plans that the city has implemented and their relationship to some of the themes that you brought up today?
I don't know if I know the specifics enough to be thinking about that. I think that, like, to be speaking on it, I think that, we just need to be keeping an eye on a few important themes in terms of looking at youth as being in a time period in their life where they're going to be making risky decisions. They're going to be more impulsive based on just their development, and then also the specific brain development processes that they're going through, and also looking at them as an important part of our community and supporting them in that role and making it easier. I think that just kind of shifting the paradigm that they should be celebrated and supported and a valuable part of the community that they are. They should be seen that way, and making sure that that's at the forefront of a lot of the policies that we're putting into place.
Wonderful, thank you. And if no one else has a question, Dr. Jankowski, do you want to say a few concluding remarks?
Thank you, Dr. Pelletier, for the presentation of your work. It's a very interesting line of work. I think it's a great example, too, of how the social sciences can hopefully inform the law. I know that's, from my understanding, it's been a little bit of a contentious arrangement, but nonetheless, I think certainly seems there is movement in that direction. I'd like to thank everyone for coming today, all the faculty, all the students, and certainly looking forward to the next one in next fall. But thanks so much. We really appreciate it.